Welcome to The Heart of the Matter, a podcast that covers legal developments from around the world. I'm your host, Stephen Lai. This podcast is brought to you by Conventus Law. In this episode, we'll be discussing the draft Indian Data Protection Bill 2022, what the key changes are, and what this bill means for businesses. Joining me in this episode is Arun Prabhu, partner and head of technology and telecom at Indian-based law firm Siro Amachad Mangaudas. Before getting to the heart of the matter, a message from our sponsor, who generously supports this podcast.
Ashford Benjamin was founded with the belief that search firms should offer a better service to clients and candidates. This means taking the time to provide a genuine partnership, understanding our clients' and candidates' needs, and proactively advising on the best course of action, utilizing the decades of experience in our industry specialisms, including risk, compliance, business and legal recruitment consultancy, located in central Hong Kong, serving Asia Pacific.
Hello, Arun. Welcome to the show.
Thanks, Stephen. Pleasure to be here.
Fantastic. Well, in this episode, we'll be talking about the Indian data protection laws, what's been happening in the last year or so, and what we're expecting going forward. So it's great to have you on here to share your thoughts with us. Now, Arun, I'm going to dive straight in. In the tech law space, over the last 6 months, a lot has happened in India. Can you just give us a quick recap about the latest developments in this field and where we're heading in the areas of technology and the law?
Well, it's a bit of a new rule book, almost in entirety, Stephen. Much of the legislation governing the space is proposed to be completely rewritten. And I think the pace of change is only going to accelerate in the days to come. So obviously there's the big three, which is firstly the digital personal data protection bill, which is a reiteration of an earlier, which is a completely fresh draft, which has come out. We've obviously discussed previous versions of draft legislations as way back as 2017, which came out on this. 2018 obviously was the report of the committee and the first draft of that bill, which looked a lot like the GDPR if you looked at it right, with a few Indian aspects to it. But what we're seeing now is a completely different creature. It's a lot smaller, it's a lot leaner, and I would say the closest analogy I found to it is Singapore's personal data protection regime. It's more prescriptive, it's much briefer, and at the risk of oversimplifying it, it's a little bit more business friendly than the earlier format. We can obviously talk about that in detail as we get into that specific legislation. But at the same time, we're seeing significant changes in other spaces as well. So there's a new telecom law out. This is again draft legislation, but it intends to replace a set of 3 legislations which dates back to 1885. So it's a lot of very fundamental legal structural work is being sort of torn apart and replaced. Again, it's a much more simplified document. It's drafted in very, very simple English. And again, there are positives and negatives of that, which we can get into. But fundamentally, it looks at a very, very simple approach to regulation. And then the third one, which is really what everyone is sort of eagerly anticipating, is the Digital India Act. Now, that's actually supposed to replace our omnibus legislation, which is called the Information Technology Act. That started in the year 2000 as a means of enforcing the United Nations Convention on Trade and enabling electronic contracting. But that was sort of Frankensteined into a creature which covered things like cyber risk and fraud, security, protection of confidential information, electronic signatures, cyber crime and cyber offenses, and so on. So it sort of grew into a multi-headed monster, but that is proposed to be replaced in entirety with the stack of, the Personal Data Protection Bill, which will obviously cover everything privacy related. And then the Digital India Act, which will actually, again, completely replace the architecture surrounding the regulation of technology. So we're seeing an almost completely new rule book in India. And it's obviously very interesting times to be a technology lawyer.
Yeah, I would imagine. I'm still thinking about the Telecoms Act. It's first time since 1885, you say? So
yeah, but Look, I mean, again, speaking candidly, the things have been amended periodically. It was a great piece of legislation way back in 1885, and the concept of the telegraph has been stretched extensively to cover everything from the internet to OTT and so on and so forth. And this was the case in several other jurisdictions, right? I mean, even in Australia or the UK, and before they sort of refreshed it in the early 2000s, they had some fairly dated laws as well. I think in India, this 1885 legislation actually was the base of a fairly tall stack of laws, rules. There was a regulatory body called TRAI which sits on it. Then there was the TDSAT which does disputes. There's a whole bunch of tariff orders, interconnect orders, tremendous litigation before every court of law. And now all of that sort of has to be, and then there's obviously the licensing regime because telecom is a licensed activity in India. So there's a bunch of multi-100-page telecom licenses which were written on the basis of the old law. Interestingly, this law looks to replace a lot of that. Again, the intent is simplification. In one conversation, we've heard that the idea is to cut the telecom license down to a few pages, which is almost unheard of, just given how much these things tend to be worth and how much runs on them. So very, very interesting times in terms of regulatory intent, simplicity, ease of doing business, reducing the amount of complexity around laws. But again, as we get into each of these laws, we'll see that this may have come with mixed results because there's obviously a balance to be found between being very prescriptive and detailed and laying everything down in a piece of law, or leaving a lot of it to delegated legislation, which essentially kicks the can down the road. And perhaps it kicks it to less able hands because you're talking about, a delegated regulator rather than the legislature. And then there is also the possibility that the absence of clear, detailed standards in certain places may lead to ambiguity and impair ease of doing business. So it's a little bit of a mixed bag, and lots to unpack there.
It sounds like these upcoming laws, new legislation is going to be more business friendly, and I think in the world of sort of confusion and so fragmented, right? The data, if you look at data protection laws, there's not a one sort of single go-to law in the world. Is there? Every it's almost like every country is doing their own thing at the moment. So I would imagine a more prescriptive law may actually be welcomed by the business community, because after all, they just want a bit of clarity, right?
So I think you make a great point there. Look, the GDPR was at some point in the heady early 2000s was considered the gold standard. Everybody was looking to the world to move in that direction. And then I think between Brexit, the way the world has changed, the increased balkanization of the internet, the importance of digital sovereignty, the fact that private actors are wielding just so much power on the internet, I think everybody sort of stepped away from that as the standard and looked to innovative ways to do it. Even in Europe, you're finding interesting pieces of innovation which sort of chip away at the sort of grand edifice that's there. So I think there is clear recognition in India that we need an Indian solution. We need something that enables business while at the same time protecting essential citizens' rights. I also feel that there is obviously recognition that large volumes of data need to be processed and dealt with by government at whatever level in order to develop and deliver sort of citizen services. And too much of a constraint on that is potentially problematic. The other interesting layer you have in India, of course, is that our fundamental right to privacy. Our constitutional fundamental right to privacy was reiterated as recently as 2017 by our Supreme Court in what led to the drafting of this legislation. So there's always going to be a very interesting judicial overlay, regardless of how much or how little this law says. Almost everything that the government does and instrumentalities that the government do will be open to challenge before constitutional courts. And they've not been shy, as you're aware, to lay down some fairly prescriptive stuff. So it's likely to be. There's likely to be a lot of back and forth before things sort of settle on this, regardless of how detailed the law is. But I think just as a community, we're at the point where no law at all is probably the worst of all outcomes. And so something that's brief and crisp and easy to enact and easy to enforce, hopefully, may be a great solution in the near to medium term, with obviously the rough edges getting sanded off by constitutional courts, maybe additional restraints being put by them, and so on and so forth as time goes along.
Yeah, you know what? You're absolutely right. Just look at crypto. Some countries, it's so much confusion right now. with crypto.
Yeah.
Can't predict anything. There's no certainty. So I think you made a really good point there, actually.
And we've been the poster child of this, right? And in all the wrong ways. We've had a crypto. I mean, I was in a public event recently where the Minister of State for Information Technology was questioned on, hey, what about blockchain and what about Web3 and so on? And he said, well, do everything but don't do crypto. Obviously, this was in the lighter vein, but we're a bit of a poster child for inconsistent regulation on emerging technology as far as crypto is concerned. It's an industry that's both from a taxation perspective and from a just financial services perspective suffered significantly because of the position in India. One hopes that we don't go down that road in relation to any of the other bigger legislations, because crypto was sort of it was a disruptive influence to some degree in the economy. This will affect mainstream economy and especially the growing digital economy in much more tangible ways.
Yeah, exactly. Now we're gonna move on. We're gonna go into the data protection bill. In November last year, 2022, the Ministry of Electronics and Information Technology, is it MITI? Is it MITI?
Yep,
MITI.
We can MITI.
So the mighty Ministry of Electronics and Information Technology, they released a draft Indian Data Protection Bill, 2022. Mm-hmm. Now, how is this fundamentally different from previous iterations of the draft data protection legislations?
Like I sort of foreshadowed in my earlier response, right? It's a much simpler beast. The earlier legislation obviously was based on the GDPR plus. So you took all of the complexity of the GDPR and then you added on some uniquely Indian flavor to it. At one point, it included things like non-personal data. It included a fairly onerous set of multiple sort of tiered obligations and so on. This law, a lot simpler, a lot briefer. It's down to about 20 pages. It's extremely simple. Only one tier of data, no classification of either sensitive or critical data or any of that. It's just data is either personal or it's not. Very limited scope in terms of applicability. It just applies to digital processing of personal data. Clear exclusions for manual processing, exclusions for, as you might recognize from Singapore, historical records, exclusions for domestic processing and personal processing, and so on and so forth. Clearly, there's a exclusion also for certain types of activities, which is proposed in terms of governmental activities. So there's this very, very interesting concept, again, taken from Singapore called deemed consent, which basically assumes deemed consent for a bunch of reasons, ranging from legislative activities, the enforcement of court orders, what you would otherwise know as reasonable purpose activities in Europe, like credit rating, fraud prevention, cybersecurity, stuff like that, but under a deemed consent concept here. And also, just in terms of the way in which this is done, data subject rights are, again, while they've been diluted in certain places, they've been sharpened in others. There's now an absolute right to breach notification. So all breaches have to be notified to data subjects. But at the same time, for instance, certain other obligations have been sort of toned down a little bit. The regulator has changed. What was earlier contemplated as an entity which would, pass guidance, delegated legislation, create standards, and so on and so forth, has now been sort of trimmed off into what is mostly an adjudicatory body. It basically just resolves disputes. So you can complain to them, they'll evaluate the complaints, determine whether or not there's been a breach, and they'll pass down a fine. Fines are still significant, though. Unlike the last formulation of relevant global turnover, it's down to a fixed rupee amount, but it's a significant rupee amount. It's about 500 crore Indian rupees, which is obviously, everyone sort of jumping up to take notice of. And then, and of course, on the all-important data localization piece, that can has been firmly kicked down the road. The bill basically says the government is going to notify whitelisted sort of trusted corridors, basically locations to which data can be transferred and how data can be transferred to those locations. So basically that will become clearer once delegated legislation comes out or once the rules on it come out on that particular section. Now, I must caution, of course, that this is obviously all early stage stuff. It's a first draft of a completely new legislation. No comments have gone in on. I mean, the comments period is closed, but from what I understand, several several thousand comments have come in from various quarters, including from ourselves. One hopes that the next version of it will sand off some of these rough edges and hopefully, be a more fit for purpose. But if I were to sort of step back and look at both versions and say, this is a much leaner, simpler, easier to comply with prescriptive version. The previous iteration, to my mind, was a little bit ornate. It was heavy. It was complex, and obviously, this version has been, I think, received a little better by industry. While there are obviously concerns, industry seems more confident about being able to actually comply with it.
You mentioned it several times now that the bill is more streamlined, it is more compact, designed to be more business friendly. Do you think the bill will have a positive impact on cross-border data flows, and do you think it will help promote the outsourcing of data processing in India? Will this bill help that?
That's actually dependent. That answer depends on which direction. What's great about this bill is that the outsourcing exception now has been made very clear. It's hard coded into the law. So as long as you receive data pertaining to people who are not resident in India under a contract for the purposes of processing, you're actually excluded from the bulk of the obligations under this law, including consent and notice and breach and so on and so forth. Your obligation is limited to essentially maintaining essential or reasonable security practices and procedures. So to that extent, it's actually simpler in terms of inflow of data. As far as the outflow of data is concerned, well, like I mentioned, the extent to which data can be sent out will depend on trusted corridors which the government is proposing to set up. So that piece, frankly, remains to be seen. What is clear, of course, is that ambiguity doesn't help anyone. So one big theme you've seen across the comments that have gone in on this is, hey, tell us what's okay and what's not. And, that's the basis on which we'll sort of come to you.
Data processing, outsourcing, and other areas of outsourcing. India is probably the global leader in that market. I would say, obviously highly educated, most people are bilingual, and obviously the experience or the quality of work is up to a certain standard. So I would imagine if this bill is going to have a positive impact, it would just cement India's position in that space.
Absolutely. Look, again, I think there's a bit of a multi-layer analysis here. Obviously, the bill is very clear that it's hands-off on outsourcing activity. At the same time, we will see that this being a bit of a strategic sovereign exercise. Other countries will want to see, firstly, that India has a valid and effective enforcement mechanism in relation to data controls, right? Whether those are contractual controls, whether those are statutory measures. Just given the experience in Europe surrounding Schrems 2, I think everybody will want to see that there's a certain base layer of protection that's available in the country to which the data is actually flowing. And so these bilateral arrangements or these trusted corridors hold potential in terms of both that, ensuring that, as well as, on a reciprocal basis, allowing the outflow of Indian data as well. You must remember that India already has a strong localization regime in several sectors. Payment data, for instance, is one sector where there's been a localization regime in place for some time. Insurance, telecoms, and so on and so forth. So we're no stranger to localization, and we're no stranger to the concept of digital sovereignty. I think the intent here is obviously to find a right balance between enabling data flows while protecting sovereign interests.
Fantastic. Well, thank you, Aram. That's all the time we have for this episode. I look forward to talking to you when you're back for episode 2.
Thanks so much, Stephen. Look forward to speaking again.
Thank you, listeners, for listening, and I look forward to talking to you on our next episode.